Let's go ahead and start. Let's put phones away. So we've got papers to hand back. I'll do that at the end of class. I will try to save myself 5 minutes to do it. If I neglect to do that and you have to rush off to another class, then just make sure to come find me and get your paper back. I've got office hours today at 3:30. Vanessa has office hours tomorrow at 12:30. I have office hours Thursday at 11. The next paper is due Monday, a week from yesterday. So if you haven't started working on that one yet, take a look at that on the syllabus. And if you got any questions and concerns about the upcoming paper, and or if you have any questions or concerns about the feedback you get on this paper, make sure to come see us. And if none of the regularly posted office hour times work for you, the best procedure is shoot an email to me and Vanessa and say, none of those regular times work for me, here's some times when I'm free, and then one of us will get back to you with an appointment. Questions about any of that? So, our topic today is executive power and national security in particular, focused mostly on the George W. Bush administration following the terrorist attacks on September 11th, 2001, which I know most of y'all are too young to have a clear memory of this, or were not even born. So it's ancient history now. For those of us who lived through it and have memory of it, right? Obviously, extraordinary day in the nation's history, and led to, among other things, a wide variety of constitutional conflicts in the wake of the terrorist attacks. It is clear, so a couple things I want to say just to start. So President Bush, George W. Bush, and his administration, right, so not just the president, but all the different lawyers and policymakers who work with him at the Justice Department and the White House and the like, they made a number of controversial assertions of executive power after 9/11. And there's two different kinds of reasons for that. One reason is 9/11. Right, whoever the president was would have made some controversial expansions of executive power, whether it was Al Gore or Hillary Clinton or Donald Trump or Barack Obama, right, in the wake of those horrible terrorist attacks. There is, of course, enormous pressure on the president to respond in whatever ways he or she can come up with to respond, right, and whoever is up in there is going to push the envelope a little bit and do whatever they think is necessary to defend U.S. national security interests, right? So just the nature of the terrorist attacks themselves, as with other national security emergencies, although this is a pretty extreme case, right, is likely to lead whoever the president is to do lots of stuff, right, to try to prevent it from happening again and to punish the people who are responsible for it. Right? So that's one kind of explanation. There's also a different kind of explanation, which is that the Bush administration was staffed with a number of influential figures who were committed to expansive understandings of executive power before 9/11. Right? Most prominent is Dick Cheney, who was the vice president, who had a long career in public service. He was a member of the House of Representatives from Wyoming. And at that time, back in the 80s, he got all caught up in the Iran-Contra investigations during the Reagan administration. He was on the committee that investigated that. And he weighed in on his views about executive power back then in the 80s. And then he had worked in a variety of other government positions. Long and distinguished record of public service and a clear and well-documented record of support for a robust vision of executive power. And so he's just one guy, but he's the vice president, and he was widely described as a very influential vice president. And there's lots of other guys like him in lower level positions in the White House and the Department of Justice. And so those people are committed to expansive understandings of presidential power before the terrorist attacks. And so part of the explanation is not that the terrorist attacks caused an increase in presidential power, although that's part of the story. Part of the explanation is that the terrorist attacks created an opportunity for folks in the executive branch who already had an expansive understanding of executive power, created an opportunity for them to try to push it, right? And that's part of the story of what happened during the Bush administration. Dick Cheney was long committed to trying to expand the powers of the presidency, and here was an opportunity to do so, right? Not as famous or as powerful or as influential as Dick Cheney, but just to mention another guy whose name is going to come up, John Yoo, Y-O-O, he's Asian American. John Yoo was a legal scholar, law professor at the University of California, Berkeley, who had been appointed to a Justice Department position during the George W. Bush administration. Not a particularly high-ranking position, right? He wasn't famous or anything. But at the time of the 9/11 terrorist attacks, he happened to be the Justice Department official who had the most expertise and experience with national security law, right? He was the highest-ranking Justice Department lawyer who had substantial experience with national security law. And he wound up playing a very significant role. And he also had a long and well-documented record of an expansive, through his academic ratings, right, of an expansive understanding of presidential power. So he played an influential role, too. Okay, so what happened? 2 weeks after the terrorist attacks, so on September 25th, 2001, John Yoo wrote a legal memo. John Yoo worked in the Justice Department's Office of Legal Counsel, which is a usually fairly obscure office in the Department of Justice, whose job is to provide legal advice to the White House. Right? If the White House wants to adopt a policy and they need legal advice on what they're allowed to do and what they're not allowed to do, they call the Office of Legal Counsel, and they have lawyers on staff who do the research, and they prepare detailed memos. And those memos, if you read them, most of them, the ones that aren't classified, are publicly available on DOJ's website. If you read them, they're almost like judicial opinions, right? They are lengthy and thorough and scholarly analyses of a particular legal issue that explore both sides and come to some recommendation, right? They're not judicial opinions because they're not issued by courts. They're just part of the executive branch. It's just a recommendation, but they have that kind of flavor. On September 25th, John Yoo wrote a legal memo arguing that the centralization of authority in the president alone is particularly crucial in matters of national defense, war, and foreign policy, where a unitary executive can evaluate threats, consider policy choices, and mobilize national resources with a speed and energy that is far superior to any other branch. Let me just flag that one term of his there, because that's going to come up a couple times. A unitary executive can evaluate threats, consider policy choices, and mobilize national resources with a speed and energy far superior to any other branch. What does that term mean?
Like the executive branch has like more authority over the other two branches?
So he is saying that. What else?
He's saying one person can make a decision a lot easier than it's 435 or however many are in.
And what can one person do better than 435 in particular?
Speed.
Yeah, that one person can decide something faster than 435 people. What else? There's another thing one person can do better. At least one other thing. Yeah.
Be more discreet.
Secrecy, right? 435 people debating something, even if you kick the reporters out of the room, right? One of them is unhappy with how the debate goes. They're going to walk out and they're going to call a reporter, right? What? Like, how are you going to keep it secret if there's 435 people deciding it, right? All the way back to Alexander Hamilton, who argued in the Federalist Papers in favor of a strong understanding of executive power, people have argued that the presidency, the executive branch, is unitary on purpose, meaning not that one guy does all the work, but that one guy ultimately has all the authority. Right? It is unitary on purpose because a single person can make decisions more quickly and more secretly than a big group of people. And so particularly on matters of national security, the executive branch should be understood as unitary. Ultimately, all of the power rests with one person. John Yu's legal memos from this period and his legal scholarship from earlier in his career quote Alexander Hamilton all the time. Right? Among the framers, Hamilton had the broadest vision of executive power. And so Yu tends to quote him. The problem, of course, is that there are other framers who had somewhat different visions of executive power and tend to emphasize checks and balances more. Right? Okay, yes, all right, we want one guy who's commander-in-chief of the Army and Navy, but we are also a little worried about what one guy is going to do all by himself, right? So we got this whole checks and balances thing, right? President's the commander-in-chief, but only Congress can declare war. That kind of thing, right? And so there's three different ways to think about executive power under our constitutional system as it is operating today in the national security context, which is obviously very different from the framers' context. One possible answer is congressional supremacy, which is probably the answer that most of the framers would have given. Not Alexander Hamilton, but most of the rest of the framers would have said, ultimately, Congress is the lawmaker, right? Congress is the only branch that directly represents the people. We, on purpose, gave Congress the sole power to declare war, right? President's job is to enforce the laws that Congress makes, right? Under the British system, right, in England, the executive, the Crown, had 100% control over external affairs, right? We go into war with somebody, totally up to the king to decide. Right? Making treaties, appointing ambassadors, raising armies and navies, declaring war, completely up to the executive to decide in 18th century England. Right? And the framers were pretty clearly trying to depart from that. Sometimes they departed from it by leaving the power with the executive branch, but imposing checks on it. Right? So the president can negotiate a treaty, but the Senate has to ratify it. The president appoints ambassadors, but the Senate has to confirm them. Right? So the executive still has that power, but not by himself. That's what the framers did sometimes. And sometimes they took things that had been part of executive power in Britain, and they gave them to the legislature. Right? The power to declare war was the king's, but here it's Congress's. Right? So most scholars of the founding would say that the framers, most of them, had a pretty robust vision of congressional authority, right? Even on national security matters. Most scholars would also say that vision is not going to work anymore, right? That is not going to work in today's world, right? Congressional supremacy in matters of national security and foreign affairs is unworkable, right? There are too many dangers, right? Too many different countries with weapons of mass destruction that at the push of a button can kill millions of people, right? In the modern system of warfare, the president's powers are going to have to be bigger than they used to be in the 18th century, right? So that's one possibility. A second possibility is the opposite, right? Presidential supremacy, right? That is basically what John Yu argues for, and Dick Cheney, pretty much. President is supreme, right? Like on matters of war and national security and foreign affairs, the president has the authority to do whatever he wants, right? The president's role, anything that fits within the concept of executive power is completely up to the president to exercise at his discretion, right? Because that power is unitary. Obviously, this creates some dangers, but the framers did it on purpose on this account because of the value of speed and secrecy, right, which are important to our national security, right? The president is commander-in-chief of the Army and Navy, and so whatever he says the Army and Navy should do, nobody can tell him otherwise. So John Yoo wrote a memo dated August 1st, 2002, which is usually called the torture memo, which said, the president enjoys complete discretion in the exercise of his commander-in-chief authority and in conducting operations against hostile forces. Right? The president enjoys complete discretion in the exercise of his commander-in-chief authority and in conducting operations against hostile forces, including the authority to order abusive interrogation practices that are prohibited by federal law. Prohibited by federal law. Torture, cruel, inhuman, and degrading treatment of enemy detainees is prohibited by federal law, but the president has the authority to order it anyway because it's part of war making, and he's the only commander-in-chief. John Yoo writes in that memo. Right? So that's option number 2. Option number 3 is some kind of shared power. Right? Which is probably the only constitutionally legitimate option, if I can put it that way. Right? The first option has a lot. The other 2 options both have some support in the founding record. The first one is completely unworkable. The second one, most scholars would say, is inconsistent with the framers' commitment to checks and balances. The third one seems consistent broadly with constitutional principles, right? We got a complicated system of multiple institutions that are supposed to work together. It's really hard to figure out how it's supposed to work in practice, right? Well, what does that mean that they're going to share powers? Like, who's going to decide something, right? How do we figure that out in actual practice, right? That's the one we're stuck with. It's not the one John Yoo wants. It's not the one Dick Cheney wants. But most scholars would say this is the one we're stuck with. We got to figure out some kind of workable way for the president and Congress and the courts, when necessary, to weigh in with different views on what we should be doing on some particular question of national security. Right? Justice Jackson's concurring opinion in the Steele Seizure case is relevant here, right? Remember, he says, well, the president does something controversial and seemingly unilateral. How do we try to figure out if he's allowed to do that? Well, let's look. Is he really doing this all by himself, or is he doing it with some congressional support? If Congress passed a statute that authorizes this action and then the president did it, his power's at its maximum, right? He's probably on good, safe ground there, right? If Congress hasn't addressed the issue at all, that's kind of an ambiguous, murky situation. If Congress has prohibited the action that the president is now trying to take, the president is probably on thin ice, right? Why would the president be allowed to do something that Congress has prohibited, right? So that's Jackson's framework, which may or may not be the correct approach, but it has for sure been influential. Okay, so let me give you some specific examples from post 9/11. One of the first things that happened is we launched military action in Afghanistan. Right, the terrorist attacks had been committed by a terrorist network called Al-Qaeda, which was being harbored and sheltered by the governing Taliban regime in Afghanistan. And on September 14th, 2001, 3 days after the attacks, Congress passed a law called the Authorization for Use of Military Force. For a variety of complicated reasons, both legal and political, Congress virtually never actually declares war anymore, but Congress does sometimes vote to authorize the use of military force, right? Think about the War Powers Act that we talked about before spring break, which says we should not be engaged in wars or warlike actions without congressional authorization. The president can do something temporarily, but then he's got to report to Congress, and Congress has got to authorize it, right? So this is an authorization for use of military force, and here's what it said. Congress authorized the president to use all necessary and appropriate force against those nations, organizations, or persons that he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. Right? So that, the language is pretty broad, right? The president is authorized to use all necessary and appropriate force, right? But its targets are limited and defined, right? Not against anybody he wants, right? It says all necessary and appropriate force against nations, organizations, or persons that planned, authorized, committed, or aided these terrorist attacks or harbored the people who did so, right? So that is clearly an authorization of military action against al-Qaeda and the Taliban regime in Afghanistan. Maybe the president would come up with some additional intelligence, like linking some other terrorist networks or states to the actions, and then it would also be authorization for use of military force against them. It did not, on its face, on its terms, did not apply to Iraq, right? The Saddam Hussein regime in Iraq had no connection to the terrorist attacks. None of the terrorist attackers were Iraqi nationals. Al-Qaeda and the Iraqi government, in fact, hated each other and were engaged in periodic armed and subtler forms of conflict in the Middle East. They were not on the same side in any conventional Middle Eastern conflicts, and they had nothing to do with each other. So it did not authorize military action in Iraq. So presumably, if the president also wanted to launch military action in Iraq, he would have to come back to Congress for another authorization of the use of military force, which he did in October of 2002. But in the meantime, right, so in September 2001, right after the attacks, Congress authorizes use of military force against al-Qaeda and anybody sheltering them. We launched military action in Afghanistan, which is still going on to some extent today, right? Longest war in U.S. history by some accounts. The following year, the Bush administration asked for congressional authorization to launch military action against Iraq as well, and Congress has a debate and ultimately authorizes it, and that military action is initiated in the spring of 2003. But in the meantime, the Justice Department lawyers, right, John Yoo and others, were writing memos. And by the way, most of these memos that we're referring to were classified when they were first written and only subsequently released, right? So these are secret. This is secret internal executive branch legal guidance. John Yoo wrote a memo in September of 2001, right? So still very short. This is the first memo I quoted from, September 25th, 2001, just 2 weeks after the attack, in which he said in this memo that the president has constitutional authority to deploy military force wherever and whenever he thinks is necessary, right? So the following year, they go to Congress and they ask for Congress to authorize military action in Iraq. But meanwhile, in their pocket, they have a Justice Department memo that says you can do it even if Congress doesn't authorize it. Nobody knew about that, but they had it in their pocket, right? They're asking Congress to authorize it, but if Congress had declined to authorize it, they might have done it anyway, because they had legal guidance from their own Justice Department lawyers that said the president can do it anyway. He is commander-in-chief, unitary. He can launch military force wherever and whenever he wants, regardless of Congress's views, right? Which, by the way, means that the War Powers Act is unconstitutional. Because the War Powers Act says he can't do that. So John Yoo's position is that that law unduly tries to limit the president's power. Congress is not allowed to limit the president's power as commander-in-chief. So that's one front, right? When and where is the president allowed to initiate military hostilities? right? Meanwhile, an additional front. Shortly after 9/11, President Bush authorized the National Security Agency to conduct warrantless electronic eavesdropping on certain suspected supporters of al-Qaeda, including some on American soil. As you may recall from before spring break, this was illegal, right? The Foreign Intelligence Surveillance Act, enacted in 1978 in the wake of Nixon administration abuses that had come to light, prohibited electronic eavesdropping in foreign intelligence matters without a warrant, right? Created a special court in D.C. with special procedures to allow the National Security Agency to get these warrants secretly and quickly, but you needed the warrant, right? Bush administration issues an order saying NSA can conduct this eavesdropping without a warrant, right? And they start conducting it without going to the court. They start listening in on electronic communications. And they wrote memos, secret memos at the time, justifying these policies. They tried to come up with some technical readings of the 1978 FISA law, which most lawyers are like that. They're like, oh, FISA doesn't really apply to this situation. Most lawyers are like that. The argument is not very strong. They also tried to argue that this law, the authorization of use of military force, superseded FISA. Right? This is more recent. FISA is 1978. This is in 2001. This is more recent. If this one said, oh yeah, the president can conduct warrantless wiretapping without a warrant in the following kinds of situations, then that would supersede the earlier law. But this one does not say anything about that. Right? I read you basically the whole operative language. It's really short. It's like one paragraph. President may use all necessary and appropriate force against the persons and organizations and states that committed these attacks or are sheltering them. Does not say anything at all about eavesdropping and intelligence gathering, which do not ordinarily fall under the words all necessary and appropriate force. In addition, it turns out, although this was secret at the time too, the Bush administration, this was enacted 3 days after 9/11. The Bush administration at the time asked for language authorizing expanded intelligence gathering powers, which Congress declined to provide. 3 days after 9/11, Congress still pushed back a little bit. They're like, no. Yes, you can go to war in Afghanistan. We're on board with that. We know Al-Qaeda's there. But eavesdropping on American soil without a warrant, we'll have that conversation another time. No, we're not putting that in there. They had asked for it. Congress had declined to put it in there. So it does not seem like that law grants expanded eavesdropping powers. The third thing the Bush administration lawyers argued is, well, then FISA is unconstitutional. Just like we think the War Powers Act is unconstitutional. FISA says, here is the only legally allowed procedure for the U.S. government to conduct foreign intelligence gathering, right? Electronic eavesdropping, right? Listening in or reading in on people's electronic communications. Here's the only legitimate legal procedures you're allowed to do that by. That law is unconstitutional, the Bush administration lawyers say, because the commander-in-chief can do it however he wants to do it. And if Congress is trying to say this is the only way he's allowed to do it, that is an unconstitutional infringement on the president's powers. He can do it however he wants to do it. Right? Foreign intelligence gathering is part of his power as commander-in-chief. That's what they argued. Secret memo. This whole policy was secret. Nobody knew publicly that NSA was doing this. Nobody knew publicly that Bush administration lawyers had authorized it. Right? Completely secret. Right? At the time. But it's a policy response to the terrorist attacks, which involves some broad assertions of the president's power to engage in unilateral action. Right? Again, they are arguing that the president can authorize the use of techniques that Congress has banned. Right? They are illegal under federal law, and the president can authorize them anyway because of this. That's the argument. I should probably tell this story. So there's one famous anecdote, again, secret at the time. So the Bush administration order that authorized this expanded NSA surveillance power, they said that it had to be reauthorized every 45 days, right? They're like, well, it's controversial new techniques we're using here. Let's make sure it's still necessary. So the Justice Department has to sign off on this again every 45 days to make sure we're still allowed to do this. The Attorney General was John Ashcroft at the time. He was briefly hospitalized, being prepped for emergency surgery. And so he had signed over his powers as Attorney General temporarily to his second in command, James Comey, who, until Ashcroft wakes up after surgery, James Comey is acting Attorney General. The head of OLC, Office of Legal Counsel, the part of the Justice Department where John Yoo worked, was a guy named Jack Goldsmith. Well, there had been a previous head. The previous head was Jay Bybee, no relation to Professor Bybee on campus here. Jay Bybee got nominated for a federal judgeship. So he became a judge. He wasn't at the Justice Department anymore. So the Bush administration replaced him with Jack Goldsmith, another conservative lawyer, head of Office of OLC. The 45-day window comes up, and this thing comes onto Jack Goldsmith's desk, and he's supposed to sign it to reauthorize the warrantless wiretapping. And he reads it, and he says, this is blatantly illegal. I'm not signing that. Right? What are you doing? Right? It's completely inconsistent with the 1978 FISA law. The president cannot order this on his own. I do not agree with those legal memos that were written last year. Comey, who is for a day or two, a day and a half or something, is going to be the acting Attorney General. Comey agrees with Goldsmith and says, we're not going to sign it. And they tell the White House. They go ballistic. White House counsel Alberto Gonzalez and Chief of Staff Andy Card jump in their car and head for the hospital where Ashcroft is stationed, where Ashcroft is admitted. Supposedly he's like all drugged up. I don't think he's gone through surgery yet. He's being prepped for surgery, but he's already on some narcotics, right? And he has already signed over temporarily the powers of the Attorney General anyway. But the story is they're going to show up at the hospital and try to get him to sign it. Somebody tips off Goldsmith and Comey, so they jump in the car and they head for the hospital. And on the way, they call the head of the FBI, Robert Mueller, and say, Mueller, you got agents stationed outside of the Attorney General's room? And he's like, yeah. Call them and tell them not to let anybody in the room. Right? And so they all race to the hospital. They all get there. And supposedly, this is the story as it's told, they all go into the hospital room, all four of them, right? The two from the White House and the two from the Justice Department, and they start arguing about it. And Ashcroft, though he has already signed away the powers of the Attorney General for the rest of the day, it's not even his decision to make, he sides with his people at the Justice Department and refuses to sign it. And the White House has to back down. All completely secret, right? Completely secret. Nobody knows about this until like a year or two later. And the White House and the Justice Department lawyers negotiate, and they modify the policy in some respects that we still don't know about. Still classified, the details of the policy. But they changed it enough. They changed the operational details of the NSA warrantless wiretapping policy to satisfy the Justice Department lawyers, and then Jack Goldsmith and Comey and the rest of them were willing to sign off on it. And so the story is interesting, partly because Comey and Mueller are involved, but it is a good story that captures some of there was this kind of, not like this dramatic, like from a movie scene or whatever all the time, but there was this kind of internal conflict and negotiation constantly during the Bush administration, because some of the officials in the Bush administration were very aggressively pushing the envelope on presidential power. And there were other officials in the same administration, also Republican appointees, other officials in the same administration who were resisting it. Right? They were like, nah. And Jack Goldsmith's a Republican lawyer appointed by President Bush to the Justice Department. Now he's a law professor at Harvard. Right? He's a conservative lawyer. He's a Republican. But he's like, no, you cannot do that. Right? That's blatantly illegal. I am not signing that thing. There were repeated examples in which military lawyers, right, the uniformed lawyers at the Pentagon, disagreed with the civilian lawyers in the White House, with the uniformed lawyers arguing for narrower constructions of the president's powers in the context of national security. Right? The civilian lawyers and Vice President Cheney were trying to say we can do whatever we want. And the top lawyers at the Army and the Navy and elsewhere in the Pentagon were saying, no, you can't do it that way. And they had all these behind-the-scenes negotiations, right? Repeated examples of that. So the administration was not all on the same page, right? Some of its officials were really aggressively pushing presidential power, right? One other context to note where these debates happen, well, two other contexts, I guess, real quickly. One is about detentions and interrogations, right? So remember, one of these memos is usually called the torture memo, right? Because John Hughes' legal advice to the White House was that the president can authorize torture, even though it's banned by federal law, right? So this is, again, similar to FISA. FISA says you can't conduct this kind of wiretapping. Bush administration authorized the NSA to do it anyway. Federal law says you cannot torture captured detainees. Bush administration authorized it anyway, right? They set up a secret black sites prison operation around the world, right? The CIA ran undisclosed detention and interrogation facilities located in other countries that agreed to let us set them up, where captured terrorists and alleged terrorists would be brought for interrogation, right? And the president authorized the use of enhanced interrogation techniques, they sometimes call them, such as waterboarding, which is widely regarded as a form of torture that is banned under U.S. federal law. White House counsel Gonzalez, in addition to banned under U.S. federal law, is also banned under a variety of treaties that the U.S. has signed and ratified, like the Geneva Conventions, which ban cruel, inhuman, and degrading treatment of captured detainees. White House counsel Alberto Gonzalez had a famous statement in January 2002 where he said, "This war against terrorism is a new kind of war. The new paradigm renders obsolete Geneva's strict limitations on questioning of enemy prisoners and renders quaint some of its provisions." So the White House counsel thinks that the Geneva Conventions are obsolete and quaint, but they are a treaty that the U.S. government has signed and ratified in which we have agreed to the whole world, right, under a legally binding international treaty, that we are not going to engage in torture. We can engage in torture anyway. The most famous part of John Hughes' torture memo is the part that says, well, torture, what actually counts as torture? Yes, torture is banned under federal law, but in the administration's view, interrogation techniques only amount to torture if they inflict severe pain equivalent in intensity to the pain accompanying serious physical injury, such as organ failure, impairment of bodily function, or even death. Right? That's our definition of torture. As long as you're not causing organ failure or death, we don't think it's torture. The memo also said, Congress may no more regulate the president's ability to detain and interrogate enemy combatants than it may regulate his ability to direct troop movements on the battlefield. Right? Same argument. Congress says torture is illegal. Congress says you can't conduct electronic eavesdropping without a warrant. Congress says the president can't initiate military hostilities and keep them going without Congress approving within 3 months. Right? The Bush administration lawyers say all of those laws are unconstitutional because all of them are efforts by Congress to tell the commander-in-chief what he is or is not allowed to do. He is the commander-in-chief. Executive power is unitary. Nobody is allowed to tell him what he is or is not allowed to do. Not Congress, not the courts either. They argued repeatedly. Right? His call. right? Last context, where I'll give some brief examples, is the issue of military tribunals, right? So another order issued by President Bush, and this one was at least public, right? This was not just secret memos. This was a publicly issued executive order by the president. He said that, and this is like late 2001, maybe December, I think. He says that for non-citizen enemy combatants who are captured and detained, right? So we're fighting in Afghanistan, right? We overrun an Al-Qaeda camp in Afghanistan, or our partners on the ground in Afghanistan, right? There's a military group called the Northern Alliance, which was a group of Afghanis that were also fighting against the Taliban regime. They overrun an Al-Qaeda camp, and they capture a bunch of people. And then we believe some of these people are terrorists, and they are now in our custody, right? And they're not American citizens. They can be tried in military courts, right? The Bush administration says. We are going to set up a system of military tribunals with the specific rules and procedures to be worked out by the Secretary of Defense, right, where we will try these non-citizen detainees. They did not try to apply it to American citizens. There were a couple examples of American citizens captured on the battlefield in Afghanistan, right? Folks who were, one famous white guy who had converted to Islam and gone to Afghanistan to fight on Al-Qaeda's side, and then one famous Afghani guy who just happened to have been born in the United States, right, and then moved to Afghanistan as a child and was allegedly fighting with Al-Qaeda. They did not try to apply to American citizens because of Supreme Court opinions from Reconstruction, right, which we talked about briefly from the 1860s and 70s, which we talked about in Con Law 1, where after the Civil War was over, the Supreme Court said, you can't still be using military courts to try... The war is over. There are civilian courts that are open and operating. This guy's like engaged in pro-Confederate like activities, trying to like keep the war going. Did he do something illegal? Try him in a civilian court. You can't just put him on trial in a military court. He's an American citizen, right? So those decisions, Ex parte Milligan is the famous one, led the Bush administration to not try to try American citizens in military courts. But then when it came across some American citizens, they were like, oh, what do we do with these guys? So the non-citizens were all detained initially at Bagram in Afghanistan and then at Guantanamo Bay, U.S. Naval Base in Cuba. And the American citizens they brought to American soil. And they put them in a military brig, like in South Carolina or something. And they said, okay, I don't know if we can try these guys in the military courts because they're American citizens, but we are going to detain them indefinitely in U.S. military prisons without counsel and without any ordinary due process protections and without, in fact, any promise of a trial at all, right? So non-citizens are going to put in trial in military courts, which will not follow all the rules and procedures of the Bill of Rights. Citizens, we are going to detain indefinitely without trial, right? On the president's orders. So again, controversy about whether the president's allowed to do this. On all of these fronts, there are legal challenges. And the initial response of the courts, like if you look at lower court opinions in these cases, in like 2002, 2003, right? Broad deference to the president, for the most part, right? The president, the White House, the Bush administration, however you want to put it, the executive branch, the U.S. government, was winning most of these cases initially in the lower courts. And if you think about some examples from our constitutional history, right, that maybe is not that surprising, right? Japanese internment, right, was upheld by the courts, including the Supreme Court, right? There is a lot of examples in our history of the courts declining to enforce constitutional principles during wartime. And I think the Bush administration lawyers were counting on this kind of judicial, like expecting this kind of judicial deference, right? Terrorist attacks were horrible, right? Everybody's rallying around the president. Of course, he's got to do whatever's necessary. Judges shouldn't get in the way of that, right? I think they were counting on that judicial deference to continue, and it did not really continue, right? These cases started to come to the Supreme Court, and the Supreme Court, which had a Republican majority at the time, repeatedly pushed back. The Bush administration didn't lose all of them, but they lost multiple cases in the Supreme Court on these issues. I'll give you some examples. In 2004, the court decided two cases. The first one was called Rosal versus Bush. These should all be listed on the handout. Yeah. One of the Bush administration strategies is for non-citizen detainees, we are not going to bring them onto U.S. soil. Right? We are going to detain them either at Bagram Air Force Base in Afghanistan or at the U.S. Naval Base, Guantanamo Bay. And the reason we are going to do that is because we believe those offshore military bases are outside the jurisdiction of U.S. civilian courts. Right? We do not believe that U.S. civilian courts in the United States have any authority to hear appeals from detainees not in the United States, right? Military detainees not in the United States. In Rosal versus Bush, the Supreme Court said that was wrong, 5-4. Habeas jurisdiction, right? A detainee at Guantanamo got a lawyer to, a military-appointed lawyer, in fact, to appeal his detention to the civilian courts, right? File a habeas appeal, right? The U.S. Constitution says everybody has the right to habeas corpus, which is the right to petition a judge to say that you are being illegally detained. And it's an ancient writ that dates back to Magna Carta in Britain. Constitution expressly guarantees it. Supreme Court says 5-4, habeas jurisdiction, right? The right to decide whether somebody is being illegally detained extends to detainees at the U.S. Naval Base at Guantanamo Bay. The other case that same year was about the detention of American citizens. Yasser Hamdi was the Afghani guy I mentioned who had been born in the United States. He was picked up in Afghanistan, and when they figured out, and he was detained by the U.S. military, and then when they figured out he was an American citizen, they brought him to a military facility in the United States and detained him there without counsel and without a trial. Bush administration lost in that one too. And that one was 8-1 on the Supreme Court. And I think the Bush administration lawyers were genuinely surprised about that. Right? This is a conservative court with a Republican majority during a time of national security emergency with a Republican president. I think they thought they were going to win. And they lose 8-1. Right? I know there's some bad examples in American history, like Japanese internment and the like. But when you start, here's the thing, like with any constitutional issue, if the folks on one particular side of it, right, if the folks in one particular branch of government, right, try to push things too far, it is possible that that will backfire, right? When you start arguing in court that the president can lock people up, including American citizens, indefinitely, without trial, without a lawyer, without any contact with their families, with no end in sight. This was their argument. We can detain him indefinitely on the president's orders without trial, and that the federal courts have no authority to review that detention. The federal courts are like, what are you doing? Like, no, you cannot do that. That is not compatible with our system of constitutional checks and balances. Right? The president does not have the unilateral authority to detain somebody forever without a trial. How is that consistent with the Bill of Rights? Right? No. 8-1. You cannot do that. Right? Dude is an American citizen in U.S. custody. Did he do something illegal or did he not do something illegal? Right? Put him on trial. Right? My favorite opinion in this case is Justice Scalia's opinion, which I don't say every day. Yeah, well...
I want to know who's the one.
Yeah. Oh, the one is Clarence Thomas. I'll tell you about his in a second. His is not my favorite. My favorite is Justice Scalia's. He writes a concurring opinion, joined by Justice Stevens. Stevens, a relatively liberal justice. He actually was also a Republican appointee, appointed by Ford. But Scalia, a relatively conservative justice, very conservative justice. Stevens, a relatively liberal justice. They joined a concurring opinion together, and here's what it said. It said... the Constitution authorizes the suspension of habeas corpus during times of rebellion or invasion when the public safety may require it, right? That's what it says. This is the same provision that came up when Lincoln suspended habeas corpus at the beginning of the Civil War, right? It says explicitly, right, the privilege of the writ of habeas corpus shall not be suspended except in cases of rebellion or invasion when the public safety may require it. And Lincoln was like, dude, this is clearly a case of rebellion and the public safety requires it. And the dispute at the time was whether Lincoln could do it by himself because Congress was not in session, right? And Lincoln said, I'm calling Congress back into session, and when they get here, I'm going to give them a speech and I'm going to tell them what I did and why I did it, and then it's up to them. But in the meantime, I got to suspend it because I'm the only one here, right? Same provision. Scalia says, clearly, Congress is allowed to suspend the privilege of the writ of habeas corpus, which, what does that mean? Another way to put that is, Congress is allowed to authorize the indefinite detention of people without a trial. Right? Habeas corpus means I'm a judge to review whether I'm being lawfully detained. The suspension of habeas corpus means, for the time being, judges can't review whether you're unlawfully detained. Right? You can be detained for the time being because the public safety may require it. Congress has the unquestionable authority to make such a law, Scalia says. But Congress has not done it. And if Congress wants to do it, they have to have an open and public debate before the American people saying, here is the national security situation that we think authorizes the indefinite detention of American citizens in U.S. military prisons without a trial. And if they convince the American people, awesome. That is our law for the remainder, as long as public safety requires it, till Congress changes the law again. But Congress has not done that. They got to do it in public. And they got to vote for it on the record. That is how habeas corpus can lawfully be suspended under our Constitution. And Congress has done no such thing. The President, just on his own unilateral say-so, has issued an executive order saying, in his judgment, the public safety requires it, and so we're going to detain these folks indefinitely. Justice Thomas dissents. There's a quote from his opinion on the handout. First two quotes from these on the handout are from these different memos I was talking about. Here's Justice Thomas's. This opinion, I'll read some of it in a second. This dissenting opinion in Hamdi versus Rumsfeld is, I think, I'm trying to think if there's been something more recent. I think this is the best, and maybe really only, definitely the best, clear statement from the Supreme Court itself in support of this idea. Right? There are tons of memos written in the executive branch in support of this idea. Supreme Court has not supported this idea. One justice on the Supreme Court has clearly supported it, Justice Thomas. The executive branch, acting pursuant to the powers vested in the President by the Constitution and with explicit congressional approval, has determined that Yasser Hamdi is an enemy combatant and should be detained. This detention falls squarely within the federal government's war powers, and we, the judges, lack the expertise and capacity to second-guess that decision. The founders intended that the President have primary responsibility, along with necessary power, to protect the national security and conduct the nation's foreign relations. They did so principally because the structural advantages of a unitary executive are essential in these domains. President's Commander-in-Chief. Capturing and detaining people is part of warfare, right? If we're fighting against some enemies and we don't just kill them all, I think we're going to wind up capturing some, and then we are detaining them and got to figure out what to do with them. That is part of warfare. And so it is up to the President alone to decide how to do that. Justice Clarence Thomas, and nobody else says. Right? Questions about any of that? Yeah.
So if I were writing for my paper about like congressional power,
Yeah.
I could cite this article, or not article, decision.
Yep. So one of the things, so for sure, so I've been using this assignment for paper number 3 for a long time, for a while now, and what is the like approximately 20-year scope of your lifetimes? It shifts by a year every year, right? And so, but since 9/11, for sure, a topic that I've gotten lots of papers about is presidential power, or the balance between presidential and congressional power, and it's a great topic. And so just here to throw something out, just to make it complicated, right? So it is clear that presidential power has expanded a lot over the full course of our constitutional history. It is clear that that expansion has continued during your lifetimes, right? Presidential power has continued to expand during 9/11. But there have also been repeated efforts, sometimes by Congress, more so in the 70s and 80s, more often by the court in recent years, to push back, right? And so if the Bush administration tries to expand presidential power a lot, and the court pushes back against some of those efforts, then the trick for the paper is to try to figure out, well, what's the overall story? Like, did the Bush administration succeed at all? Did the court stop them in their tracks? Would the court decisions turn out inconsequential and the Bush administration kept pushing and Obama and Trump after them kept pushing? Were they successful in some ways but not in others? That's the trick to try to figure out. Yeah.
I think they were successful in expanding, but just as far as like Hamdi Rumsfeld, had that gone the other way, that would have been such a precedent.
They would have been way more successful for sure, and it would be,
That would have been insane. Just the idea that the executive branch can just detain any U.S. citizen indefinitely, that could get so out of hand so fast, especially in today's America.
There's a history of it in other democratic states, right, where because of various national security situations, governments that are basically liberal democracies, for the most part, right, have sometimes authorized unilateral executive detentions, right? Detentions of people without approval by courts, right? Courts have not convicted this guy of anything, but the executive says he should be detained. And there's all kinds of problems with that, right? I mean, you can recognize the national security situations that might sometimes lead people to think that is necessary, and maybe it is sometimes necessary, but it for sure is liable to abuse, right? Right? The whole concept of checks and balances is that we're not putting all the power in one guy's hands, right? That's the whole idea of dividing governmental power up in our constitutional system. In ordinary times, the only way you're supposed to be detained by the U.S. government, right, is if Congress has passed a law criminalizing something, you have violated that law, the executive branch has prosecuted you, and the judicial branch has then convicted and sentenced you. That is ordinarily, and the judicial branch, when it's convicting and sentencing you, has all these complicated provisions in the Bill of Rights that it's got to follow, right? So this is trying to sidestep all of that. I should say, too, in Hamdi, so there's multiple opinions in the case. Thomas says, yes, the Bush administration can do this. Scalia and Stevens say, no, they clearly cannot do this. Either Congress has to suspend habeas corpus, or this guy's an American citizen on American soil, the full protections of the Bill of Rights apply. Justice O'Connor writes the court's main opinion, and she tries to split the difference. And she tries to say, there's some famous quotes in there about we got to limit executive power even during wartime. She says something like a state of war is not a blank check for the president, right, to do whatever he wants, right? But she also says, but of course the national security needs, we got to balance that a little bit, and we got to give the president some leeway. And what they ultimately say is they say that the president can detain this guy and does not necessarily have to give him all of the protections of the Bill of Rights, right? But they have to give him some kind of fair and impartial process, right? Unquestionably, he has the right to counsel, Justice O'Connor wrote, right? You can't lock somebody up without some fair and impartial process in which he's represented by a lawyer, right? So they try to split the difference a little bit there and give the president a little bit of leeway, right? But they got to give him a lawyer, right? And they can't detain him forever without trial.
Oh, I had a question going back to the torture thing.
Yeah.
We don't hear about the Eighth Amendment very much. Has that ever come up Supreme Court-wise? Or?
It does. So one thing that makes a lot of these cases complicated is the court's general tendency, right, that does not always stick to this, but its general tendency is to try to decide things on narrower grounds if narrower grounds are available, right? And so if Congress passes a law banning torture and then the president tells the CIA to torture some people, right? Now, and then the guy who was tortured subsequently gets a lawyer, you could argue, oh, the president's authorization of torture violated the Eighth Amendment. The U.S. government's engaging in cruel and unusual punishment. And you're going to argue that. And you're also going to argue the president's authorization of torture violated the congressional ban on torture. Right? And relying on that congressional statute is a narrower ground for the court because it leaves open the question, right? Think of Justice Jackson's three categories. Okay, what if next time around, in our next military conflict, national security emergency, for good reason, Congress and the president together authorize torture? Would that still violate the Eighth Amendment? We haven't decided that yet. We are just deciding here that Congress banned it, so the president can't do it. Right? The president's order is invalid on statutory grounds, and we haven't addressed the constitutional issue yet. That is their preferred way to move, right? It's like if there's a narrower, deciding something on a statutory basis is always narrower than deciding it on a constitutional basis, right? Because if you decide it on the statutory basis, Congress could change the statute if it decides to. So that's what. So the Eighth Amendment in these Supreme Court decisions, there might be some lower court cases where they got to it, but in these Supreme Court decisions, it does not come up. They don't get to it. In one subsequent cases that comes to the court in 2006, it's called Hamdan versus Rumsfeld. Right, two different guys, Yasser Hamdi in the first case, and Salim Hamdan in the second case. This is about the military tribunals, right? So Yasser Hamdi was an American citizen, so they didn't put him in a military court. They brought him to the U.S. and they were just trying to detain him. Salim Hamdan was not an American citizen. He was captured in Afghanistan. He was allegedly Osama bin Laden's driver, although there was some dispute about whether he had ever engaged in any kind of actual combat against the U.S. or if he was just driving Osama bin Laden around. But he had some connections, alleged connections with Al-Qaeda. And they try to put him on trial in Guantanamo Bay, and they're the new military courts that the president has authorized. And the Supreme Court rules against the administration in this case, too. And they rely mostly on the Geneva Conventions, right? They say the main problem here is that the president is trying to authorize a process that violates a treaty that the U.S. has signed and ratified. The Geneva Conventions have some clear provisions in there about how you're allowed to treat captured detainees, including what kinds of courts you're allowed to try them in front of. And Justice Stevens says this order from the president violates those provisions of the Geneva Conventions, right? So they don't address the constitutional issue directly in that case either, because they rely mostly on that treaty. And the last, there's basically the sequence of four cases. There's some other ones during this time too, but these are the four main ones. The last one's in 2008. It's called Boumevian versus Bush. And the sequence here is somewhat complicated. So the Supreme Court had held already that habeas jurisdiction extends to Guantanamo, and that military commissions, as initially authorized by the president solely unilaterally, violate the Geneva Conventions. You can't use those anymore. And Congress, there was a Republican Congress at the time, Congress responded by passing a law called the Military Commissions Act, right? So now, if you think about Jackson's three-part framework, now President Bush is not acting by himself anymore. Congress, in the law, Congress authorized the use of military tribunals to try captured enemy detainees who weren't American citizens. They spelled out more and somewhat different rules for how those military tribunals would operate than President Bush initially had. So it's not like Congress is just authorizing exactly what the president had already done, right? They specified their own rules. But the gist of it was the same, right? They say, here's how these courts are going to work, here's how they're going to be staffed and appointed, and here's the procedures that they'll follow. And they do not have to follow all of the provisions of the Bill of Rights, right? For example, you don't get a jury of ordinary citizens. You get a jury of military officers, right? You don't get to choose a lawyer of your choice. You get a military defense lawyer appointed for you, right? Even if you have some other civilian lawyer who's willing to represent you. We're going to put limits on that. We're going to use different rules in terms of what kind of evidence is allowed to be introduced, right? Like we weren't following the Fourth Amendment and all that when we were collecting all this evidence. We've got hearsay evidence and the like that resulted from various interrogations. We're going to allow some of those forms of evidence to be introduced here, even though they would not be allowed in a civilian trial. And here's the kicker, the law said that these tribunals that we're setting up the judgments of these tribunals may not be appealed to ordinary civilian courts. There was one really narrow, complicated exception, but basically the judgments of these military tribunals cannot be appealed to civilian courts. So, in some ways, this law, which was enacted in 2006, is sort of a suspension of habeas corpus. Sort of, right? It's saying we're going to have these other kind of courts, we're going to have these tribunals, these military courts that are going to try people, and if you're being detained under the authority of those courts, you cannot appeal that to the civilian courts. And that was challenged in the Supreme Court, and the Bush administration lost again. And they said that the Military Commissions Act, the part of it that prevents appeal to the civilian courts, is unconstitutional, right? Congress is allowed to suspend habeas corpus in situations where the public safety requires it because it's a case of rebellion or invasion. But Congress has not done that here, right? The law did not explicitly say anything about we are trying to suspend habeas corpus. And in the absence of a clear suspension of habeas corpus, the civilian courts have jurisdiction, right? If somebody says they're being unlawfully detained, right, the Bill of Rights is being I'm in the custody of the U.S. government. They are violating the Bill of Rights. I got this lawyer from the ACLU or whatever wants to represent me, and they won't let me meet with him, right? That's a constitutional claim that the civilian courts ordinarily have the authority to decide, and we still have that authority, the Supreme Court said. And one of the things commentators said at the time when this one came down is just comparing the court's position in this case to some of the prior examples in the court's history that are somewhat parallel, and the court seems bolder and more willing to stand up to the president and Congress in this case. Another of the famous cases from Reconstruction, there was one that was also a habeas case where while the case was pending, right, in the Supreme Court, Congress changed the law, changed the habeas law to remove the court's jurisdiction in that very case, right, before the court decided it. And the Supreme Court backed down. They said, okay, well, we don't have jurisdiction anymore, so we dismiss this case. And they probably were going to rule in the guy's favor, people thought anyway. That's what the court did in the mid-19th century. The court in the early 21st century does not do that, right? The court has ruled against the administration a couple times already. Then Congress weighs in with a law that is basically siding with the president, right? It changes the details some, but is basically siding with the president. And the court rules against them again, right? And so the court seems to be saying, we got this system of checks and balances. It is our job to protect fundamental constitutional rights and liberties in the Bill of Rights, especially all these fair procedures about how courts are supposed to operate. We care about that stuff a lot. We are watching. We are not going to allow Congress and the President to just sidestep all of that, right? They reiterate that pretty boldly. That one's 5-4. Yeah.
If Bush replaced Rumsfeld in the Hamdi case, would Hamdi just have had to refile? Or would that have been the end of it?
No, usually when you change, the named defendant in these cases is sometimes the president himself, sometimes it's the Secretary of Defense, sometimes it's like a state governor or whatever. Usually if that position changes, they just retitle the case and it continues. There are some situations in which, if the government changes the policy, then sometimes you have to start over. Like President Trump's 3 different versions of an executive order banning multiple categories of Muslim immigrants to the United States. Each time the Trump administration has repealed one of those orders and issued a new one, the legal challenges have had to start over because it's a different question you're deciding now, the policy. But if just a person changes, they just flip the name out. So I'm going to hand back papers in a second. I guess just the last thing I'll say about this is to some extent, every president tries to expand presidential power. Like, that is not surprising. If you are the president, then you like presidential power, right? Barack Obama, when he was a presidential candidate, was very critical, in 2008, was very critical of some of these unilateral assertions of executive power by the Bush administration, and he did walk some of them back, right? They dismantled the CIA Black Sites prison program. He attempted to close the detention facility at Guantanamo Bay, but Congress wouldn't let him. Right, he issued an executive order attempting to initiate the closing of that facility, but Congress overruled that. But on other fronts, President Obama himself pushed the boundaries of unilateral presidential power. Right, he took a number of actions, including on national security and some on domestic policy, in which he boldly pushed the limits of executive power. Right, so if you're a president, presidential power seems attractive. Every president, to some extent, tries to expand presidential power. But in our history, some presidents have tried to push that envelope further than others, partly maybe because of their own views, partly because of the circumstances that they find themselves in. In the wake of 9/11, President Bush and his administration clearly tried to push the limit more than normal, more than typical. And in particular, one of the things that was most striking about it, that I think is really different from Lincoln. Like Bush tried to compare a lot of his actions to Lincoln's actions, but I really think they're different in this respect. Lincoln's controversial assertions of executive power were made in public, right? A public order suspending the writ of habeas corpus, and then calling Congress back into session, and then a public speech to Congress defending the order. They were made in public, and he explicitly said, it's Congress's call, right? This is what I did unilaterally because Congress was not in session. But now you're here, it's your call. Whatever law you pass, that's the one I'll enforce. The Bush administration repeatedly made unilateral assertions of executive power secretly, right? The NSA surveillance was secret. We didn't find out about it until it got leaked to the New York Times after the 2004 election. It actually got leaked to them before the election. And in a controversial decision, they did not report on it till after the election. Completely secret expansion of executive power, and the opposite argument about Congress, right? We are not saying we're submitting it to Congress and we'll follow whatever policy they enact. We are saying the opposite. We are saying Congress is not allowed to tell the president what to do in this situation. That might be merited in the wake of the horrible terrorist attacks, but it is a striking pushing of the envelope, right? Unilateral assertions of executive power in secret combined with the explicit argument that Congress is not allowed to do anything about it, right? That's different. Lincoln did not do any of that, right? So I'll stop there, and I'll hand back some papers. I got I guess I'll start at the back of the alphabet this time. Seems fair. Ziobro, Abigail.
Oh, I'm taking that paper.
You can take yours. Zach Vega, Brandon Tuskus, Emma Thompson, Josh Strauss, Emma, Jack, it's not here, Schlosser, Sarah Schleicher, Jordan Schenker, Sadie Sarsfield, Colin, not here, Sadie.
Josh Strauss.
What's that?
Josh Strauss.
Brian Sanchez, Amanda Russo, Quentin Russo, Rodney Reynoso, Christian Perez, Vanessa Ortiz, Nachman, Stephen Mayone, Ian Masters, Stephen Lee, Marcus Lane, Jimmy Huang, Adam Hoban, Abigail Henry. Abigail here.
Perez.
What's that? Perez. Michael Hanley. Rebecca Goodsell. Scott Glanzel. Tom Frederking. Armando Ferreira. Brianna Ferguson. Eric Farrar.
No, Tom for the
Carolina. Daniel. Joseph Dragon. Hunter Dickerson. Cameron. Carl Cotoneo. Taylor Cook. Joseph Cohen. Connor Coggins. Caitlin. Chandler Champion. Josh Carney. Manny. Ben Cannon. Maurice Brown. Caitlin Brinklow. Rachel.
Thank you.
Brian. Anton here. Kaylin. Abdulaziz Al-Salati. Tyler.